All right, so Chicago Title proudly presents Liens and Your Transaction. Always a little commercial at the beginning. We offer the Start in Here mobile deposit for your clients with resale transactions. It can save them a trip here to our office to bring in their earnest money deposit, and your escrow officer or sales exec can help you get that link sent to facilitate that process. Along with that, there is a whole Start in Here digital opening package that we send to the buyer and seller on each transaction. We encourage you to let your clients know that they will be getting an email about this from their escrow team, and that they can just submit everything in a very quick Q&A, upload a couple of documents format. But if they have any questions, they can call their escrow officer. And just to let you know, we're doing this to keep all of the private information that we are asked to collect about people as secure as possible. This information goes directly into a secure portal, and so it helps us to minimize the possibility of the wire fraud that continues to be very prevalent in our resale transactions. If you have any questions at all, we're happy to share more about that. And for our agents only at this time, we're working on getting this open up to lenders. We do have the In Here portal, which you can get an invitation when you start a transaction with us, register for an account, and then have access to all of your transactions online, where you'll receive notifications about what is going on in the transaction. We've set a few milestone notifications, and you can also just kind of keep an eye on things and look at your pre and stuff like that. So again, not going into a lot of detail here today, but that is available, and you can certainly talk with your Chicago Title sales exec or me. And without further ado, we're going to dive right in, and I will let Anna start talking.
Good morning, everyone. Happy Friday. I'm glad everybody is here today to further their education in our industry. So happy to see everybody. So today we're going to be talking about liens in the transaction. And what is a lien? So basically a lien is, according to the dictionary, a charge upon real or personal property for the satisfaction of some debt or duty ordinarily arising by operation of law. For example, the bank had a lien on our house. So anything that's going to affect the transaction, that's a lien, that any type of lien that could be attached to the home. So it's very good to understand various types of liens, and we're going to go through all of those today. The lien secures their interest to the property, to the particular property, whether it may have been on the property while the homeowner had owned the property, or if the homeowner has secured debt otherwise and did not use their home as collateral, but the debt is now in delinquent status, where the lien holder could have placed the lien on the property. So just to kind of make everyone aware that a lien can affect a property, whether the property was used as to secure or not. Okay. A lien is typically filed against a real property, but like I said, it could be filed against an individual that owns a piece of property, and now that lien is attached to that property. Okay. A type of lien could be a judgment. Basically an obligation, a debt, whether it could be a credit card or a personal loan. And so it went into default status. And so it can go through the courts and be filed against the person, and then in due time affect the property. And then a certificate of evidence evidencing such a decree. So basically when they file a judgment, then there's a process where it gets filed, and then it records with the county, and so that's how it gets attached to the property. Okay. Liens and judgments can affect your closing. So this is where it comes it comes in handy for you to review your preliminary title report. The preliminary title report is the report that we issue on each and every transaction where we're giving you the lowdown on what's affecting that particular property. So it's very important that you do review your preliminary title report. Once you're reviewing it and you see something that you do not understand, please reach out to your escrow officer and have a conversation. It may not be anything significant, but guess what? If it is significant, you want to be ahead of the game. Okay. So the prelim lists the exceptions, the liens, the encumbrances, and other risks that will not be insured against if a title policy is issued. So at no point should you get confused where the prelim that we issue is that actual policy. It's the pre to the policy. And so we're letting you know what needs to be taken care of within the transaction and what stays with the property through the transaction, through closing, and onto the purchaser. Other requirements and provisions that affect the transaction are going to be listed in our notes section. So you'll have the exception sections, which that is your main concern. Your main concern is our exceptions section of the preliminary title report. But when you get to the note section is just a communication between title and escrow. And then also certain lenders do take some information from this note section to satisfy some of their underwriting requirements. But basically, title is telling escrow, these are the things that you need to address or review to make sure that once we are at closing, this information has been reviewed and taken care of. So, and then we can go ahead and move forward to closing and issue policies. We use the information as well as the statement information to clear anything that may be present, an obstacle to closing to clear title. So it's very important. A lot of the clients don't like to complete the statement information, but it's important because if they have a common last name, I don't know about you, but I don't want to be paying somebody else's debt or somebody else's bills. So if they have a common last name, we use the statement information to identify whether that lien truly belongs to them or not. So if it doesn't belong to them, it's, no harm, no foul. We move on. That information is kept safely within our file. We have a fiduciary duty to keep safe all the information that we collect from your clients. This is our role. So once we collect the statement information, we only use it within our internal departments of title and escrow and for only our purpose. And so once we determine that a lien is not your client's, we can move forward. If we determine that the lien is your client's, then we have to go ahead. We'll notify the parties, whether we'll notify the seller, we'll notify the listing agent, we'll notify the lender. We won't give specifics to the lender, but we will notify the lender that there's an issue, and we'll notify the selling agent and the buyer, but we will not give specifics to the selling agent and the buyer, because we still have to, some of this, even though it's of record, some of the information is still private. So we will go ahead and work with the listing agent and the seller to kind of get through what we have to, whether it's an abstract or whatever kind of lien, and try to move forward to get to a resolution. Okay, so the overview of the preliminary title report, we do offer a detailed class. We go in depth into the preliminary title report. I'm not going to do that today because that class, I encourage everyone to take that class at least once a year. It's very good to just refresh your skills on reading a preliminary title report. But the overview of the preliminary title report you see is your cover page. It's going to just give you a summary of what's going on, who's the title officer, who's the escrow officer, who owns the property, the vesting, and a legal description. Legal description usually follows this page because it's quite lengthy most times, but this is what's going to be your first page. Your second page is going to start going over the matters, the taxes, government liens come first and foremost. Can I have the slide move forward, please? Sorry.
Anna, before you continue, there was a question previously on the SI. It says, so what triggers the need to obtain an SI on a client, or do you do it on all?
Okay, great question. As of this moment, we do not collect SIs from buyers at the beginning at all. We have changed our policies a year or so back, but in regards to a seller, so when Jennifer had mentioned that in here, app and all that good stuff, we request information from your sellers at the beginning of the transaction. So when they fill out the information through the in here portal, we take that information and it's in our file. So when that preliminary title report comes out and we need a statement of information from the seller, we already have that information in our file and we send it directly to title to start clearing the statement information requirement. So as of right now, through in here, that information is already being requested at the beginning of your transaction. Now, keep in mind, we are unable to do that if we do not have great contact information, cell phone number and email address for each seller. Okay, so I hope that answers that question. Now, in regards to a buyer, we'll go over that a little bit later too, but since we don't collect SIs from the buyers and we don't really go down that path about running, the name, we do have to run names for buyers for federal tax liens and bankruptcies. So we know, so just to keep that in mind, if we are asking your buyer for a statement information is because we are finding something that may be similar to your buyer's name that is affecting a tax lien or a bankruptcy. Okay, so that's a little bit of a tidbit. As I said, I went over this. The first page is just a summary of your property, the type of policy we're going to offer, who owns the property, and the legal description, contact information for your title and escrow officers. Okay.
So, and I would say the one thing to know on this is that everybody that shows as currently vested in title, those are the people that any liens that may be attached to them as well as the property could affect the transaction as a seller. So every single person on there.
And I'm happy that you brought that information up because there is a misconception that if a property is in a trust, that it's protected from any liens or judgments for that matter. So what I mean by when I say that is Anna Gettman has an abstract judgment and Anna Gettman owns a piece of property, but the property is vested as Anna Gettman, trustee of the Anna Gettman Living Trust. Now, just because the property is held in trust does not mean that that property is protected from that judgment, from that lien, because I still, as an individual, am responsible for that lien and that judgment, and I have assets, whether they're in that trust or not. So that transaction may be subject to, having to take care of that abstract judgment. So on the opposite end of that scenario, Anna Gettman has a personal lien, and there's a property that the property is held in a trust, but the trust reads Anna Gettman, successor trustee of the Ryan Gettman Family Trust. Well, because I'm just the successor trustee and the property is held in the Ryan Gettman Trust, my judgment is not going to be attached to that property. It's not going to be required to be satisfied because that's my personal judgment, because the property is held in the trust in another capacity of a trust. So just to be clear, because a lot of people think, oh, well, why are we having to deal with the lien? That lien is against my seller as an individual and the property is held in the trust. So there's a little bit of a fine line there, just so everyone knows. Okay. So I'm glad that you mentioned that, Jennifer. That's something that comes up often. And some people don't really understand how we have to go about it. Okay, so like I was saying earlier, government liens, the government always comes first, as we all know. The government has to get their money first before anybody else. So you're always going to see the property taxes at the beginning of the preliminary title report, whether they're current, whether they're supplementals, or whether they're delinquent. They're always going to be at the beginning of your preliminary title report because they hold that first position no matter what. And so you'll see there if there's any back taxes, if there's any escape taxes or delinquency, if the property is in jeopardy of going through a tax sale, meaning that the owner has not paid taxes, their property taxes in over 5 years, this is where you will see that. Okay. And then after that, and also any Melrose, but if Melrose is part of that, you'll also see that in your natural hazard disclosure report within that. So, and then remember, all of our preliminary title reports are hyperlinked. So anything, when you saw that previous page, the blue, our vesting would be hyperlinked, and any recordable documents are going to be hyperlinked, where this 5 and 6 CC&Rs, you can click on them and get the actual PDF copy of the recorded document. Okay. So following this, then once you have gone through your any governmental liens, also within the tax section, you're also, if your property has gone through a HARO or PACE program, that will also be in the following the tax section. It doesn't jump out at you. It doesn't say, hey, I'm a HARO lien, hey, I'm a PACE lien. It's worded as a contractual assessment. And so it'll also be on your preliminary title report right after your taxes. So I want to make sure it's very important that you do review your prelim. And if you see something kind of funky following your taxes, most likely it's a HARO or PACE, but it's usually worded as a contractual assessment. Okay.
And we'll
then
feature that in some later slides.
Yes. And then so after that, you're going to have your easements and all that good stuff. And then following the easements are going to be your your liens that people voluntarily put on the property, i.e. your deeds of trust, your mortgages, your line of credits, your second mortgages. And so your deeds of trust are going to be here. And a lot of the times they're plain and simple, easygoing stuff that you expected. Your clients already said, I have a first, with Chase and so on and so forth. So they're going to be, in this section, but sometimes you'll have some surprises and old deeds of trust that we'll go over later down the slides. But this is the section the deeds of trust will be. And then following this section will be it'll still be voluntary liens because the homeowner voluntarily put a lien, and it would be your solar, your UCCs, your power purchase agreements, your lease agreements. This is it'll follow your deeds of trust. Now, typically with solar, about 80% of the time, you're going to see 2 documents that are recorded in association with the solar. One's going to be the agreement between the homeowner and the solar company, and the other is going to be a financing statement. And that's how the solar company secures their financial interest to the property. Okay. So that's just a quick review of the preliminary title report, just to give you an idea of what liens look like on the prelim. Oftentimes they are going to be simple, easygoing, easy reading, but there's going to be times where it's going to look a little funky, and I encourage you to reach out to us, and if you don't understand it or you think something doesn't look right, give us a call, shoot us an email. We'll be happy to go over those things with you. And again, I encourage you to take that preliminary title report class that we offer at least once a year. So mortgage matters, we need a demand. Once we get the preliminary title report and we see that there is an open deed of trust, we need a demand from that particular lender or beneficiary, whether if it's an institutional lender or if it's a private beneficiary. So I had mentioned old deeds of trust earlier. There's times where we will see an old deed of trust from 1980s, whatever the case may be. Now we're going into the 90s where there's old deeds of trust and we cannot reach the beneficiary if it's a private beneficiary, or we cannot reach the institutional lender, whether they've gone out of business or they're defunct or any of that matter. We can't just say, oh, well, it's an old deed of trust. These people are long gone. You know, it's not a big deal. They're never going to come after their money or whatever the case may be. Well, that's not the case. If we have to make every attempt, if it's an institutional lender, to see if someone has bought out their portfolio. And so we have to go through our channels that we have access to see and kind of follow the breadcrumbs, for that matter, to find out who ultimately ended up with their portfolio, and if there's actually a zero balance. And if there's a zero balance, they are going to give us a zero balance and a release or reconveyance, a substitution of trustee and full reconveyance. And so this takes some time. Same thing with a private beneficiary. If they have passed away, we have to follow the breadcrumbs and see if there's any heirs, and if the heirs have any knowledge of the loan being paid off in full. And then once, if they can verify that, then they have to provide documentation that they have the power to sign for the deceased, and that they can actually sign, and then they provide us that documentation to be reviewed, and then ultimately they can sign for that release or that full reconveyance. So there's a whole process. Now, if none of this can be done, then we have to go through a process called a lost note bond. That can take up to 40, well, it will take up to 45 days, depending on the bond company. And then because the seller has to apply, they actually have to make an application to the bond company, because the bond company has to make sure that they do their due diligence and they are too protected. So there's an application process that the seller has to submit to the bond company. The bond company will then do a review and then decide that they will issue a bond. And they too have their own fees. It's not something that's associated with our title and escrow fees. Those fees are on top of the normal title and escrow fees. And it can be anywhere between 1.5 to 2.5 times the face value of the note / deed of trust that we are dealing with. So if it's $100,000 deed of trust, it can be anywhere between 1.5 to 2.5 times for those fees. And then once that they issue the bond, it gets recorded. 30 days have to pass before to make sure that no one's coming forward. And then at the end of the 30 days, then we can move on with our title and escrow process. So it's a little bit of a pause. They have to do their thing. Once their thing is done, then we can move forward. And the reason why I say 45 days is because we have to wait those 30 days, but we have no control over that application process. We kind of estimate, 2 weeks, 15 days for that application process, because again, we're at the mercy of a third party, and we're at the mercy of the seller actually putting together the requirements for that application, filling out that application, and turning in that application to the bond company. So we like to give that cushion of 2 weeks. So most sellers do it in a timely manner because they want to close, but just so you know. And then, so once that's done, so you're not completely dead in the water if you have an old deed of trust, but it does take some time, whether we're trying to locate who took over the institutional lender's portfolio, or trying to locate a deceased heir and then go through that process, or we can't do those two things, we go to the lost note and bond. Okay. And then anything that we are going to obtain, whether it's a reconveyance, full reconveyance, loss, it all has to be recorded at closing or before closing, before we can complete our transaction. Okay. Other requirements and provisions which are reflected as notes, which I talked about earlier, that which are removed. You won't see these notes on your title policy, whether you're an owner's title or you're receiving an owner's title policy, and these don't show on the lender's title policy. But this is what that looks like for you when you're reviewing the preliminary title report. It just kind of lets it lets us know what title is telling us that we need to do before we can close. Okay, there's not much on that one. It's just How does solar affect your escrow? There's going to be a bullet point on here and I'm going to emphasize it now. Please do not think that escrow is handling the solar transfer, or wait till escrow. Don't wait until escrow is asking you status of the solar. Like, it's very important that you have your clients start that solar process. So this is how it affects your escrow. When you lease or purchase a solar for your home, the lien is recorded against the property and or a financing statement. And the reason why I say and or is because sometimes there's certain solar situations that only a UCC is recorded. But going back here, like I said, typically you're going to see 2 recorded documents that affect the solar. I've seen up to 4. I have some homes, some transactions have had 2 solar agreements with 2 different solar companies. Not quite sure how that was handled at the beginning, but we were having to get 4 different releases, 2 releases for the agreement and 2 UCC terminations. So just keep an eye out. Sometimes if you see, oh my God, there's 4, did title make a mistake? Typically not. And for whatever reason, sellers are going into contracts with 2 different solar companies. So
Anna, just conversationally, I've heard a lot of people have been adding solar because they bought an electric car or their bill was too much every year and things like that. So just seeing solar on the roof doesn't mean that it is all under one contract, and have that conversation up front with the listing when you're taking the listing.
Mm-hmm. And then going into that too, having that conversation, and if within that conversation, your seller's like, oh my gosh, don't worry about it, solar's owned. And then don't just take that for granted that they're telling you that the solar is owned. Question it a little bit. Just say, oh, okay, that's wonderful. However, did you just pay the solar company outright directly? Did you go through a credit union? Because in their minds, since they're not leasing and they're not doing a monthly type of payment, they sometimes these solar companies refer them to credit unions that just do solar loans. Just because the solar company may have gotten all of their money doesn't mean that there is not an actual loan for the solar. And so that's what I mean, where sometimes you'll only see a UCC financing statement and no solar agreement, because what happens is they did pay the solar company all the money, but they got the money from a credit union. So always keep that in mind. And for whatever reason, and I don't know why, these sellers, they think that if they go that route, they're like, oh no, the solar's owned. And then all of a sudden we have the prelim comes out and we see a UCC, and 9 times out of 10 that has to be paid off at closing. That it's I haven't had an escrow where there was just a UCC and the funds for the solar system was obtained through a credit union, that it was assumed by the buyer. I've had 1 or 2, and it was something where the buyer had to go through the credit union and go through that whole application process and stuff. But oftentimes when it's that situation, the solar is actually being paid off with an escrow. Factors to consider in the transfer of lease solar and escrow. Like I said earlier, the solar panels are affixed to the property and it's truly not part of the home. And the reason why I said earlier that please remember to have your clients start the solar process, because it's not considered real property, because it is affixed. I've had it, I believe it or not, I've had an escrow where the seller took the solar system with them. It's a thing. So just know that it could affect it. This particular situation affected the transaction and delayed our transaction because they had to, the solar company was very involved with our transaction because the fact that the seller was taking the solar system with them to their new home. So when you have your sellers start the process with the solar company to transfer, they're going to need a lot of the information they're going to need a lot of information about the buyer to provide to them, their names, their contact information, because they won't talk to the buyer without the seller telling them, I'm selling the home. I need to start the transfer, because it's the whole third party. It's privacy. They're not going to talk to anybody. So don't think that we can do it, because they're not going to talk to us. They get correspondence from us when we reach out to the solar company and say, we need the releases for these, but they actually don't communicate with us until that seller lets them know that they're selling the home and they need the transfer process. They still won't communicate with us. There are some certain solar companies that are very helpful, where they give us updates saying, we received your request, however, we can't proceed until we go, run the credit for the buyer and do all that transfer process. Oftentimes we hear crickets and we're often reaching back out, like, what's the status? And they won't respond to us. We can do all that every day, all day, until your clients, the buyers and the sellers, do their thing. Then they will respond. They're like, oh yeah, the buyer just got approved. We're starting the transfer process. Once the transfer process is complete, we'll send you the documents for release. There are 2 solar companies that won't even give us releases until we give them a copy of the recorded grant deed in that buyer's name. So that was a little bit of a struggle with new lenders for the buyers, because they wanted to see a release. So just keep that in mind too. Factors to consider in the transfer of owned solar in escrow. So if it's owned, we're good. If it's truly owned, that the seller did not get a loan through a credit union to pay the solar company, if they actually just paid it outright, we're good. So if you see panels up on the roof and you ask about them and they're like, no, it's owned, smooth sailing, you will not see anything on the preliminary title report. I just had an escrow 2 weeks ago open. Listing agent was like, there's solar. Prelim came out, no solar. I sent it back to title, because we're human. We make mistakes too. I sent it back to title and I said, can you just double check one more time to make sure we didn't miss anything? Because we can't ask you to make sure, or ask you to ask those sellers that question again if we don't double check ourselves. So sure enough, I sent it back to title. They checked it again, and there was nothing came up with solar. So it truly was owned, and we no harm, no foul. There's nothing for us to do on our end. And it's just considered personal property, like, patio furniture, gazebo, whatever, that's between the buyers and the sellers. Okay. I already talked about the financing statement. I talked about the buyer assuming the loan. If there's a financing statement, I've seen that just a handful of times, very few. Most times it's been paid through an escrow. And then again, if the solar is owned, that's an amazing situation for the buyer.
The reason I have on the slide that all power agreement transfers would be handled outside of escrow by the buyer and seller is there have been a couple of situations where we've been asked to make sure that paperwork gets executed and to facilitate it. And that's really not something we're able to do in that situation, correct?
Yes, we cannot, when it's owned, there's nothing, we wouldn't get involved with the sale of, I don't know, or it's just like, we wouldn't get involved in like services between, a buyer and seller that they have on a piece of property. It's still personal property, and you would have to make sure that all that is taken care of before we close. So there's no loose ends. I mean, everybody wants clean closing, nothing to come back at you. So that's just something that's good for you to do before at closing. Sorry. Factors to consider in the transfer of Hero, PACE, or Y-Green funded solar in escrow. And it's not just solar. When these come up, solar is not the only thing that Hero, PACE, and Y-Green has funded. These are programs through the county, and they put these liens through the taxes for various things. It could be for roof, new windows, to to improve the home. So a lot of it is solar, but just so you know, if these you see these liens up on the preliminary title report and you're like, wait a minute, I don't have, the house doesn't have solar. Why are these liens showing up on the prelim? It's not just for solar. It could be for other items. I've even seen them for air conditioning units, roof, windows, just all kinds of things. You would be amazed. So just as a little bit of a side note. So Hero, Pace, Swaggreen, they're not assumable. They can't, most lenders will not allow it, and these programs will not allow it. They're going to have to be paid off in escrow. It's not something that's going to be able to be passed on to the buyer, or for them to, or for the buyer to go through a credit check and approval process. So you see these on the prelim, circle back to your escrow officer, say, okay, I need to do my new net sheet, because the net sheet I did not include any of this. And we've got to make sure that, especially now, that the seller is going to get, or, they're not going to get what they expected to get, because some of these are included in their taxes and they think, oh, they're my property taxes. It's going to continue with the property, and the property taxes are going to stay the same. And now the buyer is going to take over the property, and that's now their property taxes. Unfortunately, it doesn't work that way, and it's not going to end up that way. So you have to include these amounts as payoffs on your net sheets. And they are, the white greens are a little bit different than the Hero and Pace. So Hero and Pace are, they have a breakdown, and I think we have a slide that to help you to see what it, did we go through that slide already? To see like balances in the years and how the balance goes, but we don't go off of that. So please do not think, oh, okay, we have a payoff, and we have to physically order a payoff through these entities. They could take up to 30 days, and they won't provide us the payoff until the seller goes into the portal, into these particular portals. We will give them the link to the portal, and they pay anywhere between $50 to $75 demand fee. Now, it's great. I mean, everybody has to make a decision on their own, and depending on the length of the transaction. So just one thing to keep in mind with these, if we have a 30-day transaction and we order this, we're good. But if you have a lengthy transaction, just keep in mind that we're going to have to update the payoff, because they only provide us a payoff for 30 days. And if our escrow goes over the 30 days and we need an update, it's almost like doing the process all over again. The length of getting their turn time is not as lengthy, but they still charge the same. So if they charge the $50 to $75 demand fee, they're going to charge it again when we ask for an update. So just keep that in mind.
And Anna, we had a question on that in general. If everything gets held up, if the seller doesn't pay the transfer fee, is that requirement of many solar companies that the seller pay a fee to get the process started or submit paperwork?
Yes, I've had escrows where the seller didn't take any action, didn't want to pay any kind of transfer fee, and you're just in limbo. We can't do anything. So it's I've had to call listing agents and have that listing agent call the seller, have a conversation like this. I'm sorry, I understand that this is upsetting, or I'm sorry that you don't agree with this is not my fee. This is not title and escrow fee. This is your solar company's fee. This is something that you probably have in your contract. And so, yeah, this is something that if the seller does not want to pay, unfortunately, until they agree to move forward, or somehow miraculously that transfer fee gets paid, we can't do anything about it. Okay. Was that's just for that question was just for solar, correct? It wasn't my demand fee that I was talking about.
Correct.
Okay. Okay, so I do want to make one note of it. I see it. We still have to disclose to the buyer or get something from these Hero, Pace, Y Green. I've had 1 or 2 escrows where there were cash transactions. The buyer was an investor, and they didn't really, they, for the lack of better terms, they did assume these, but they needed to know what they were assuming. So that was really the only thing. But at the same time, these entities had the right to call their lien due if there's a transfer and they weren't paid off. So there is a way. I don't see it happen often that these don't get paid off in escrow and the buyers assume, but it's only with a cash buyer, and the cash buyer needs to understand that these entities can call their lien due if they don't agree with the fact that it got transferred. It's very rare since these are collected with the property taxes. So that's just a little bit of a side note. So understanding the Pace and Hero lien from the live look prelim, as I mentioned earlier today, we have an interactive prelim, a hyperlinked prelim. So these things are going to be in red, which is great. It's a great tool for you to use, because when I said earlier that they don't jump out at you when you're reading the preliminary title report, if you're just reading just the prelim, they don't jump out at you. They're not worded like, hey, I'm a lien, or I'm a deed of trust. They're just, you know, assessments of contractual so-and-so. So if you use our interactive live look prelim, they're going to be in red. Items in red are things like are saying these are important. We're going to have to deal with these before anything can happen, before you can close. And so these will be the red section of the interactive preliminary title report live look.
What? No.
And so that's just an example of what it looks like on the bottom. As I said, assessments and other matters as contained in documents entitled payment of contractual assessment. Now, this is what I was talking about too, about amount of assessment 1667.33 starting in 2014, 2015. So they'll have the breakdown of like how much every year is collected. Please don't take that as a misconception of what is going to be paid off at closing. These are just amounts. And I also keep in mind that the county, you know, it changes and they're behind. And so sometimes when these liens are placed, they don't get attached to the taxes as far as 18 months. So you can have property taxes that stay normal for an entire year, and the PACE loan was already agreed upon and started and signed for a year before, and then they'll start showing up on your taxes, you know, anywhere between 12 to 18 months later. So just make sure that you understand title or escrow has to get a demand, and those are the true amounts. Please do not rely on any amounts that are on the recorded documents. The next slide, if you hit the hyperlink on our preliminary title report, it'll bring up the actual copy of the recorded document, and it'll show you what, you know, it'll actually talk about what the PACE or Hero or Y Green loan was for and how much was taken out. Can we move forward on the next slide, please? The other way. Perfect. So here's the copy of it, and so it, you know, kind of goes over and then it's very has a lot of information, who the bond company, you know, the PACE was gone through. This is typically, you'll see the WRCOG California Hero Program. That's oftentimes that's who we see this through. Then it talks about the assessment and then the legal description. It does give the contact information if your seller is unaware of what they did. Sometimes these programs they reach out to homeowners, and the homeowner, it sounds so great to the homeowner, and they go into it and they're like, yes, it's just part of your property taxes, and they don't really understand what's going on. But now they're selling their home and they're a little bit confused. These documents that has the contact information, it has The contract number has everything on here that they're able to maybe call and have a conversation with them. But at the end of the day, this is something that's going to have to be taken care of at closing and paid off within closing. The next slide is going to show you what I talked about, the scale of where, you know, how much is being collected in which tax year. And so when she moves the slide over, you'll be able to take a look at that. Please do not, again, use those amounts to determine how much is owed left on the property, because it's not going to be anything that can be calculated on your own. But this is what it looks like. So these are the schedules that are of record on the actual contractual assessment lien. Okay, I talked a little bit about the statement of information earlier in the slides, and then this is just letting you know what we're looking for the sellers and the buyers. Sellers is basically almost everything and anything that you can possibly think of, anywhere between federal tax liens, BK bankruptcies, most judgments, child support, and spouses or other parties added to title bring all their stuff into Title II. And what that means is you add a significant other, you had a brother, you had a sister, you had a mom, you had a dad, or mom and dad add daughter or son. Anytime that you add an individual to title, you're adding whatever is affecting them financially, whether they have, you know, unsecured debt that has gone delinquent and has gone as far as, you know, a judgment being filed against them. The moment that happens is the moment that those liens affect your property that you're adding, whoever you're adding to title. So that's just something to keep in mind. So any of these items that we have a hit on through a statement of information, we have to deal with. And so just so you know, as far as buyers are concerned, as I mentioned before, there's only two things that we need to worry about, which is federal tax liens and bankruptcies. So there was a time where we would have to deal with, you know, other liens that affected the buyers, like abstract judgments and child support. We don't do that when they purchase a home. But they do get dealt with when those buyers turn into sellers, or those buyers turn into borrowers, when they're refinancing. Okay, so those are the items that we're looking for when we request for a statement of information from your client. So when we do have a hit and we do have a federal tax lien or state tax lien, there's certain things that need to be done when we actually have these things come up. So what happens is, if it's against a seller, these are our options. Escrow, first and foremost, will order the payoff, and the seller is to pay the lien at closing. Simple, something that we would do all the time. But there's other options for that seller. The escrow will hold off on ordering a payoff, and seller can contact the tax authority and negotiate a lower amount. And then once an agreement is reached, then at that time, we would reach out to the tax authority and request a payoff, because at that point, they've already made an agreement with the seller to take a lesser amount, and then to go ahead and give us a demand for the lesser amount, and then they would go ahead and release it. The thing is when these liens come up, your escrow office is going to reach out to you and to your sellers and be like, this is what's come up. First of all, do you know about it? And second of all, like we're going to need to reach out to request a demand, but before we do so, do you want to contact them first? Because if we don't do that, once escrow reaches out for a demand, that tax authority is less likely going to want to negotiate anything for a lesser amount. Okay, so we have to let you know anyways that there's a lien that has come up through a statement of information. So we do the courtesy of just saying, hey, do you want to contact the tax authority before we reach out to see if you can have a conversation with them, and so on and so forth. And then escrow, also the third option is if there's no monies to be had in the transaction, escrow will hold off ordering the payoff and seller contacts the taxing authority and negotiates the tax authority to just release the property from the lien. Doesn't mean that they're asking for the lien to be released in its entirety, but they're saying, hey, there's not much money or nothing at all coming to me. I really need to sell this house. I have this buyer. Is there any way you can release the property from the lien? And it has been done before. I've experienced it. I've had several escrows where this happened. It does take a little bit. And the tax authority does require copies of the appraisal, the closing statement, the contract, and maybe some of their personal finances. I don't know, because it's something that gets handled between the seller and the tax entity. Options for buyers, there's really none. Escrow is just to order the payoff and the buyer to pay for the lien at closing. So bankruptcy, how it affects it's the BK must be closed on the transaction if it affects the seller. If it's not closed, we must have a court order to authorize the sale. So it's just plain and simple, because if there's a BK and it's not closed, we have to have an order saying that we have authorization to close the sale. And so that would have to come through the bankruptcy attorney that would obtain that through the bankruptcy court. For buyers, it just has to be closed. We can't close a transaction with an open bankruptcy. Okay. How does child support affect the transaction? For our sellers, plain and simple, child support must be paid for and or cleared before at closing. So escrow will have to request a demand and or full satisfaction or matured installment, meaning they're current on their child support payments. And for buyers, it doesn't affect the buyer in a purchase, because we don't, we only deal with federal taxings and bankruptcies, that we said before. However, I do want your buyers to know that they will have to deal with it when they refinance or sell the property. And then other liens and judgments. I did talk about abstract judgments quite often throughout this class today. So they can be anywhere between personal liens, lines of credit that wasn't attached to the property, credit cards. They can be personal people suing other people, and mechanics liens if it's, a new construction or, owner builder, the seller, purchased the land and built it. It could be various mechanics liens. And then less pendants. Less pendants are court actions where people are suing other people. I've had siblings place a less pendants because they were suing their other siblings that they don't want the property resold. And so when you see a less pendants, it's a court action. Okay. And that's what I've got for you.
So we can open it up for questions. We've got just a couple of minutes. If you want to unmute and ask Anna your question, you're welcome to do that.
Wow. No questions.
Oh, no, I
guess
got a question, Anna. When dealing with family support regarding a child support issue or whatever, how long does it take to get that demand? Because I think everybody tends to be under the assumption that, oh, we just call them, they'll shoot the demand over in a day or so. Is that true or no?
It's not true. They're running right now at 15 days. I have 2 files right now that I'm actually waiting on child support, and I just got the one and it was at the 15th day. When I call for status, believe it or not, I'm getting correspondence saying that the person that's working on my request is working remotely. They have to come to the office to get the zero demand or the demand or the release signed. But not sure what that situation is, but right now, and it hasn't really changed much, but it's always been around 15 days and they're really sticking to the 15th day. I've had sellers call to see if they can expedite it. Sometimes it works and sometimes it doesn't. One time I got a seller to call and they got a letter within an hour, and that letter stated, that there was nothing due and all that good stuff. But then another seller called and they got a letter after a day or two, and that letter didn't really say much. It said, yes, your case is closed, but however, through the review of your case, it might be reopened if there's any arrears. So that doesn't make me too comfortable to move forward on a transaction when a letter is issued in that manner. So right now, if your client has child support, maybe have it or just ask that question. And if they have child support, we can always jump on it and get it ordered ahead of time. So at least that 15-day clock can get started.
We also had one more question on the power purchase agreement type of solar transfer, what that process looks like.
It's similar to if it's just leased solar. Basically, that contract is basically how much it's negotiated, how much that they were purchasing the power for. Rates go up and down, they fluctuate. So it's the same as a leased equipment solar transfer. The only difference is I think it's because the equipment's not being leased, just the power is being purchased. So it's a lot less. I've seen the contract before, and the contract is very minimal because there's no verbiage about maintenance on the equipment and so on and so forth. But it's basically the same process that has to be initiated by the seller and continued with the buyer.
Hey, Anna, can you talk a little bit about, because this seems to be happening a lot, and while we have people's attention, they can possibly help us, but about, I've had this a couple of times, I've had to have conversations just this week about when we do a file and we insure it in your individual names, and then you say to us, or your lender tells you, oh, title will put that in your trust after it closes. That it's a RESPA violation. We're insuring you as individuals, not as a trust, right?
So we can't transfer it into the trust after closing. However, the buyer can purchase an endorsement before closing. They have to tell us, say that they're purchasing the property and they're purchasing the property as the individual name because the lender is only going to lend to the individual and not the trust. They can purchase an endorsement so that after close of escrow, the buyer can go to whoever has managed their trust attorney, or, you know, a reputable
Doc prepper.
trust, yes, that they can put it in their trust after closing, and they're still insured as their owner's policy is intact because there's no break in the chain of title. But that endorsement has to be purchased before we close. And that endorsement is just particularly for that situation where they purchase the property as an individual and then they need to transfer it into their trust. So a lot of people do not know that when that situation does arise. I do offer that to them, but unfortunately it's at the very end of the transaction. And of course, I'm not quite sure how much, I think the pricing varies. I'd have to look that up. But if we're adding any kind of title and escrow fees at the very end, most likely the lender has already disclosed. So if that situation is something real for your buyers, I encourage you to encourage them to bring that situation up so then we can disclose properly for that endorsement. It may be minimal, it may be free, I don't know, and I apologize for not having that information, but at least it's there, it's an option and it's offered.
Yeah, I bring it up because I got yelled at saying that we put the title in the wrong name.
Uh-oh.
And I said, no, we didn't. We did what the lender tells us to do, right? So we have to do what they tell us to do. So it was just a lengthy conversation, and it seems to be coming up because I know people are concerned and they want the properties in their trust, obviously.
Mm-hmm.
So
absolutely. Wow, great.
All right. Well, thank you everybody for your time. Anna, thank you as always for doing such a fantastic job with the presentation. Please know we are here to support you in anything that you have questions about or need additional info. Just reach out. We will be sending out the recording and posting this class to our YouTube channel, Chicago Title Fresno, by the end of the day. And we look forward to seeing you on our next class.
Jen, there's one more question. I'm sorry.
Bye-bye.
Jennifer, there's one more question. I'm sorry, in the chat.
what does it mean? What does clearing child support mean? Is it referring to clearing any past dues for child support only?
Absolutely. Any arrears, any past due. If the seller is current, we still need to contact the child support department and request a matured installment, which is an actual legal document that gets recorded within our transaction stating that the seller is current. But yes, clearing child support could be either requesting that document or requesting a demand and asking to collect any arrears. Okay.